kind of celebration that you want, and you can't wait until the last minute. It's really very difficult waiting for the last minute. If you have bank accounts, which Attorney Barrow will talk to you about, if you have bank accounts, if you have any kind of assets, you need to let your attorney know, because if you don't have a will and you have assets and you don't have a will and you don't have a spouse and children and grandchildren, 99% of the time your stuff is going to the state. It's not going to nobody that you want if you don't have a will. The state is going to take it all, and I've seen it happen. So these are things that you have to prepare for. And I know as you all are sitting here, nobody wants to talk about dying. You don't want to talk about it. But it's something that you need to get together and talk about with your family and decide what it is that you'd like to do. The other thing is, if somebody dies, don't run to the bank, because as soon as you go to the bank, they're going to freeze everything. Even if your name is on that account, they're going to freeze it. Now, if you take your time and you talk to your funeral home, you can get a death certificate. If your name is on the account, you can go and get some of the money out. But if you run to the bank and they'll freeze the account, and you're out of luck. Out of luck. You're really out of luck. The other thing I wanted to say, in this folder too, I listed a form that has where you put all of your personal information, your name, your social security number, your parents' names, your mother's maiden name, that goes on your death certificate. You'd be surprised at how many people sit down and they don't know their mother's maiden name, their grandmother's maiden name. They don't know anything. They can't know it if you don't tell them. You have to tell them. So in our little pamphlet is everything in here that's going to help you make decisions to do what it is that you want to do. I don't know what else I could tell you, but besides meeting your funeral director, knowing where you want to go, don't be afraid to tell somebody. Talk about it. And I guess basically that is it. It's all, everything in here is what you need to know before you go. It tells you how to plan a funeral. It tells you how to pre-play, what your rights are. I'm very proud to say that this pre-planning, old Governor Cuomo, Mario Cuomo, called me personally and asked me to come and work with a couple of senators to get a bill passed for the pre-plan, because he had been trying for years, and the other folks didn't want no bills passed because the bill governs how funeral directors treat your money. And it took us a year, and we would go up and we would come with these laws and the verbiage, and you'd get back the next 2 weeks after the meeting, and they say, "Oh no, we didn't say that. We don't want that." And that went on until I had to do what black ladies do when they get angry, and I came home, and at that time we were just doing, there was no emailing, we were faxing, and I faxed every state senator in Albany and the assembly people. And I just told them, if you don't pass this bill, then you're telling your constituents that you want people to steal their money. Because without this law, so many of these funeral homes were taking these old people's money, and when it came time to bury them, if the family couldn't prove that they paid, it was gone. That doesn't happen today. If a funeral director steals your money, they're going to jail. Trust me, they're going to jail. So they get your money, they have to put it in an interest-bearing account. You get statements at the end of the year that your money is there. And they can't use it until you pass, and they present a death certificate. That's how they get the money to pay your funeral. And it's a blessing. It really is a blessing. It's a blessing in disguise. Okay. Anybody have any questions they want to ask? Okay. Pat.
Thank you very much. Now, I was saying we're going to hold the questions until the end, so you have notepads and pens. Just write your questions down. We're going to move along with the program. I was actually going to read Miss Audra Barra's bio, but I noticed that she has it in the package, and she has a lot of information to give, so I'm not going to read it. But I do want to say something about her. And let me tell you how I met her. And I think my girlfriend is here. Is June Allison Gray here? Where is she? She's at the back. And I don't think she minds me telling you. She asked me to come and witness for her because she was doing her trust. And if I had not done mine, I would have used her. And Miss Audra Barra was her attorney. And she was so meticulous in what she did, how she did it, that I was extremely, extremely impressed with her. And I started reading up about her, realizing that she goes around the communities and educate them in what to do, how to do it, so that we as Black people, as Hispanic people, in the minority community, we don't do what we are supposed to do. She goes around in these communities and she educates the community what to do. So I am going to not say much more, but I do want to say something else about Elder Parkinson. And for everybody that's here, I don't want you to look at him today as Elder Parkinson. Because I want you, this is how humbly I said, could you please give me a little bio? He says, no. I said, I want people to understand within this church the quality of the folks that you have that you can ask information of, and they can give it to you because he is a financial executive. And so I want you to look at him not as Elder Parkinson, because you could not pay for the services of these three folks that are actually sitting here, and they're actually doing this for free. So I ask that I want to thank each of them for just agreeing to do this, and I'm going to shut up now, and I'm going to turn it over to Attorney at Law, Ms. Audra Barra.
Thank you very much. I hope everyone can hear me. I would first like to take a minute to thank Golden Ages community, specifically Ms. Carol Bennett and Ms. Beverly Bailey, and the pastor for the opportunity to present this information today. I realize that the church sees the importance in the information that is given today. And so I'm very happy to be here to be able to present it to you. I'm going to start by giving you information, and I want you to realize that the information that I give today is not legal advice, so it shouldn't be construed as legal advice or legal opinion, or as creating an attorney-client relationship. It is just information. Okay. Can you show the presentation, please? I'm going to start by sharing with you jarring statistics about wealth in America. According to FINRA, the average white household has approximately $188,200 in wealth. So they have $188,200 in wealth, compared to just $24,100 that is for the median Black families and people of color. There is a great disparity in wealth in our families throughout America. And one of the best ways of closing this wealth gap, the difference between $188,000 and $24,000, is estate planning. However, many people don't want to plan. And people in the communities that I serve do not want to plan. And when I say I serve, I do go out to the communities. I will speak to anyone who will listen. And one of the reasons why we don't plan as a people is, one, we don't think we have anything to plan for. We don't think we have any wealth. We actually have less wealth than our white counterparts. And we don't think it's important to pass the wealth down. So every generation starts anew. If you don't pass what you have to the next generation, they can't build upon that. So every generation is starting anew. Today I'm going to show you the goals of the workshop. So the goals of the workshop are for me to teach you the rules of estate planning. It'll be a very, very high-level explanation of the rules of estate planning. And I'm going to do that today by peppering you with stories. One of them will actually be a personal experience, and others will be my professional experience. And that is so that I can shift your perspective on the importance of planning. So you realize what happens when you don't plan, or when you have a plan that is ineffective. After I've shown you the rules, I'm going to show you the different options that you have to plan. So planning is based on what your goals are. Then I'm going to illustrate the difference between creating plans and creating tools or documents and an integrated plan. So an integrated plan is something that is created by an estate planner, not a general attorney, a general practitioner, but by an estate planner. And that is where you have tools that are created for you that work together, that speak what your goals and vision is for your planning, that incorporates your family dynamics as well as your finances, as opposed to you going to LegalZoom, Susie Orman, or thinking that estate planning is a DIY area of law because it's just transactional, so I can do it myself. You have to realize that it's too important for you to do yourself. And I'm going to show you what happens when you don't realize it. So at the end of this presentation, I'm going to offer to create a plan for you if you do not already have one, but only if you're ready to plan. Do you know that each one of us in here in this sanctuary have a plan already? We have a plan because New York State creates an estate plan for each one of its residents. So you have a plan whether you've created one or not. New York State, by its laws, carried out by the courts, creates a plan for you if you ever become incapacitated and don't have a plan as to who will take care of you and who will be in charge of the things that you own, which I will commonly refer to as your stuff or your assets, but I rarely mean everything that you own. New York State also has a plan for its residents when they die. So when you die, if you haven't created your own plan, don't worry. New York State has it for you. They will even decide who will get what you had, what you left behind. They'll decide for you, and they'll decide who is in charge. And Ms. Thelma had said earlier that if you don't plan, that your property can actually end up with the state. And that is so true, and I've seen it happen as well. So let me share with you my first experience with New York State's plan. When I realized how important it was to opt out of New York State's plan and create your own plan, I had an intimate workshop with my family. I thought it was really important. Let me tell my family members all about planning and implore that they seek an attorney who's an estate planner to get a plan put in place for them. So I meet with my family and we're talking about this, and I remember sharing with them, as I will share with you, these 5 tools that you use to create an estate plan. You do not have to use all 5 of them. It's totally up to you, but it's the healthcare proxy, power of attorney, living will, and trust. And in talking about this, I remember my mother saying, "Oh, your sister sounds like she's trying to kill me off and take my stuff." So that's what my mother was saying to my brother. You better talk to her. She sounds like she's trying to kill me off. So anyway, I continued and I explained to them the importance of each one of the tools. And about 7 years later, I get this phone call from my brother. He and my aunt lived in the family home at the time, and he was in the hospital with my aunt. When he took her there, she was unconscious. By the time I got there that evening, she had regained her consciousness, but her speech was slurred. But I thought to myself, she's going to be fine, because the weeks before she was fine, the months before she was fine. To the best of my knowledge, she was going to be okay. The next morning before going to work, I went to visit her. When I went in her room, she seemed to be sleeping, but I couldn't waken her. So I went to the nursing station to find out what was going on, only to be told that she initially was admitted with a massive stroke. And over the evening, she suffered yet another stroke. So leaving the hospital that day, I realized this situation was dire. So I called my family and I told them what was going on. Here goes my mother. "Well, I hope she had that plan you're talking about before." I said, "Okay, let's go in the house. Let's see if she has the plan." So we go to the house, and what do we find? We find only one of the tools. So I said to you, New York State creates a plan, and depending on which point of your life you're at. So my aunt was at the point where New York State will create a plan for you during your lifetime. The only tool she had was the healthcare proxy. And what is the healthcare proxy? The healthcare proxy is a tool where you can nominate a person to make your healthcare decisions for you when you're unable to, right? And a lot of people know about this tool because they think, actually, that it's a medical form, not realizing that it's a legal form, not realizing that you should have the discussion with the agent before creating the form. Because if I were to ask each one of you what you would do, given being in my aunt's situation, I'm sure each one of you would say something different. Well, anyway, she nominated me to be her healthcare agent. I took it very seriously, but I realized in thinking about it that she actually gave me the God power. I could decide what procedures she received. I would decide whether she lived or died. However, she never had a discussion with me about it. I didn't know what was quality of life for her. I didn't know what type of procedures she would want or wouldn't want. So I just made the best decision that I could for her. And I continued to give her life support until she regained her consciousness, and finally, her stroke left her paralyzed on one side of her body, therefore unable to speak. So she was unable to speak. She was unable to walk. She was unable to toilet herself. She was unable to feed herself. I got her acute rehab facility, and within a year, she passed away. It's really important that we take planning seriously. The next tool that can be used during your lifetime to opt out of New York State's plan is the living will. So the living will is not where you're nominating anyone to make any decisions for you. You're actually telling your family and the medical staff attending to you whether or not you would want to receive life-sustaining treatment. Did you know that you could say, "I want to be resuscitated, but only once"? Or "I want to be resuscitated twice, and thereafter not again"? It could be so specific, the information in these tools, if you do them in a timely manner. not when you're going in for the procedure, but beforehand. Well, this particular tool gained notoriety out of a case out of Florida. So it's not just the state of New York that plans for its residents, it's every state. And for some of you who think that, oh, I'm too young to plan, this case was called the Terry Schiavo case. Terry Schiavo was in her 30s, but she was in a vegetative state. She was married, both of her parents were living, and they were fighting in court. The parents were like, oh no, don't kill my baby. The husband was said, well, his wife didn't have quality of life, so he wanted them to stop the life support. Guess who decided? The state of Florida. They decided to terminate her life. So I think very often people don't realize that it even causes infighting in families. One family member wants to keep the person alive, someone else doesn't. Later on, nobody might be speaking as a result of the lack of planning. This next tool that's listed here is one of the most important tools that there is, and it's the power of attorney. And the power of attorney is a tool where you nominate an agent to make your legal and financial decisions for you. That person can be making the decisions for you. Let's say you're out of town, out of the country. They could be handling or transacting business for you with the power of attorney. But also, it is commonly used for me when a person becomes incapacitated, loses mental capacity. And so often is the case that someone's calling my office asking me to create a power of attorney for their mother, their grandmother, their aunt, their spouse, and that person has already lost capacity. It cannot be done. In fact, I had a friend that got so upset with me the other day because she said to me, oh, I want you to create a power of attorney for my father. I said, okay, does he have mental capacity? She says, of course. I get on Zoom. I determine the father doesn't have mental capacity. I said, I can't create it. She says, who made you a doctor? Anyway, so I'm going to go back to my aunt for a moment. My aunt, who was living for a year in the rehab facility, business needed to be transacted for her. But as I said earlier, I only had a healthcare proxy, so I didn't have authority to transact business for her. And that's where I faced New York State's plan for its residents during their lifetime. And it's a guardianship. And people don't realize how costly guardianship proceedings are. So a guardianship proceeding is where the court decides if the person that they're being petitioned about really does lack capacity. So that's the first prong. Do they lack capacity? Once they determine that they lack capacity, then the court decides who will be the guardian. This is what had to happen with my aunt. They had to deem her an incapacitated person, and then the court chooses the guardian. I want to tell you that if you have a power of attorney in place, the court does not have to choose a guardian. The proceeding for guardianship under Article 81 is extremely expensive. First, it's about $10,000 now for the proceeding. It starts about there, and then just goes up depending on how family members are objecting in court. But that's not the only real cost. The other cost is that New York State is inserted in your family as a family member, because they're making decisions for the incapacitated person. And those decisions not only impact the incapacitated person, but it impacts the entire family. The court is deciding how the person's money will be spent and what it will be spent for, based on the court order. I once had a woman come to me, and she was taking care of someone, and she was hoping that I would be able to create a trust so that she could get assistance to take care of that person. When she made the appointment, my staff asked her, did she have a power of attorney? And not only did she have a power of attorney, she had a healthcare proxy and a will. She walked in with all of her tools that she had for the person that she was taking care of. And in fact, they were created by an attorney. So I sat down and I looked at them, and I had to unfortunately tell her that the power of attorney was not robust enough for me to create a trust. These were tools created by an attorney. But perhaps the attorney was not an estate planner. So I had to end up telling her she would have to petition the court for guardianship. If you have a power of attorney in place and it is robust, it is created by an estate planner, it should be sufficient to keep you out of a guardianship proceeding. I'm going to move to New York State's plan after death. So New York State's plan after death is the intestate statute. The intestate statute means you died without a plan. That's what it means, essentially. And so you've died without a will, or you've died without a trust. And so the laws of the state of New York actually state who will inherit from you. And it also will decide, the courts will decide who will be in charge of distributing your assets. Many of us think that that's okay. It's okay for the courts to decide because we know the law and we know who's going to inherit from us. But as a result of the pandemic, I want to ask you, do you not realize that we do not have a crystal ball? We don't know who's going to survive us. Not only do we not know who's going to survive us, we don't know whether they'll be able-bodied. Will they have a disability? Will they need to receive the assets but not in their names because they have judgments and creditors against them? So that's why it behooves you to create your own plan. Then there's the last will and testament, which I have lumped under New York State's plan for its residents. And the reason why it's here is because just like the dying without a will or without a plan, the last will and testament still requires New York State to come in order for people to have the authority to act. So the last will and testament is the tool where you choose who will inherit from you. And you also choose who will be in charge of your estate in terms of dispersing, distributing the assets that you leave behind. But that requires probate. And people don't realize how daunting the probate process is. This year, it's 2023. In 2020, I filed a slew of administrations and probate petitions, and 90% of them to date are still pending. My clients call up and think, are you doing your job? Yes, I'm doing my job. I take great pride in my job. I'm waiting on the courts. It is a daunting process. It's a long process. It's a frustrating process. I don't know how many of you have been through an administration or a probate. Administration is where you die without a will. The court has to give permission and authority for someone to act on behalf of the estate. And probate is where the court has to give authority for someone to act on behalf of the estate. It takes quite some time, and it's different for every person depending on who's left behind. Now I want to quickly go through non-probate assets. I'm going to try to move this presentation along because it's usually about an hour, maybe an hour and 10 minutes. Non-probate assets are the assets that you have that go to the beneficiaries outside of wills. So the court doesn't have to give someone permission to get access to your assets. Examples of these are actually when you own property as husband and wife. The law looks at the two of you as one spouse passes away, the other one owns the property by operation of law. So if a husband and wife own a bank account, own a property, own a brokerage account, anything that is titled in their two names, then when one spouse predeceases the other, the surviving spouse gets to do whatever they want with that property. So if you have a blended family, the predeceasing spouse does not get to will any share. Then there are assets with beneficiary designees. We've got the bank accounts in trust for. We have the brokerage accounts. We have the insurance policies, correct, 401ks. We have all these different accounts with beneficiaries. But what people don't tell you and what you may not realize is that you're letting an institution do your estate planning for you. Because you've listed a beneficiary, right? So you figure to yourself, well, that beneficiary is going to get that asset. But what happens when we forget to make the changes to all these different products that we own? As life happens, as we fall in love, as we fall out of love, as we divorce, as children are born, as we get married, as someone loses their mental capacity, we forget to make changes. And people sometimes don't consider that you may be giving an asset to someone that might, at the time that they receive the asset, may disqualify them from a grant, or a scholarship, or SSI, or Medicaid. Because now you have to spend down the money or not be eligible for the program. I'm going to go on to gifts. So very often we give gifts, and we think of it as a way of estate planning. So we're going to give a gift. We're going to gift our home to someone we love, a home that we're still living in. What happens when you gift your home to someone you love? You've just lost control of it. Can you refinance it without them? Can you sell it without them? And if you gift it in such a way where you add their name to the deed, then you've now exposed your asset to their creditors and yours. I once had a man come into my office and he says to me, "Ms. Barrow, I'd like you to administrate my son's estate." So I said, okay. I sat down and I began to do the intake. I said to him, "Who survived your son?" He said, "Oh, my daughter-in-law." I said, okay. I said, "Why are you asking me to administrate his estate?" He says, "Well, I gifted him my home before he died because he just assumed that his son would outlive him." That's a reasonable assumption, right? But he didn't. And now, I was charged with telling him who would be the owner of his home. Who was the owner of his home? His daughter-in-law. And who was able to administrate his estate? The daughter-in-law. Because the son, of course, didn't have a will. He was too young for that. So he totally lost control of his home. The one last thing that I'd like to tell you as a consideration about gifts, sometimes we gift our homes, and then let's take, for example, I was to gift my home to my son. And at the time that I purchased my home, I purchased it for $300,000. I gifted to him during my lifetime. I pass away. My home is worth $1 million. He goes to a closing table. He's ready to sell the property. He sells it for $1 million. He later on gets this tax bill for $249,000. Why? Because he has to pay capital gains. I gifted it to him at the value that I purchased it at, and that's his cost basis for capital gains purposes. So when he sold it for $1 million, the federal government subtracts $300,000 from $1 million, comes up with $700,000, and between the federal government and New York State, they charge him 35% of that, and he loses $249,000. But let's say instead I gifted it to him at the time of my death. Will, trust. What happens then? He gets a step up in cost basis to the $1 million. It's valued at $1 million. He sells it, zero capital gains. So quickly to what is a trust? So I realize in so many communities now, trusts are trending. And so many people have trust. They walk into my office with the trust. They're proud of themselves. They're like, Ms. Barrow, can you look at my trust? Absolutely. Trusts are trending, even though at one time we thought they were for the uber wealthy. They seem to be what to do now, so we're just doing it. We do it with anybody. With anyone who can create a trust, an attorney says they can create a trust, we get that trust. Do not get a trust from an attorney who is not going to educate you about trust. It is not something historically we know about. We know about the will. So when someone gives you this 70-page document, I think you want to know about it. You want to know what's in it. You want to be counseled. So what is a trust? A trust is a contract. It's a piece of paper. It's a piece of paper that I write that expresses what your wishes are. My clients and I design our trust together. It expresses what your wishes are, who would get what, when. It's a contract to hold property. There is a grantor, and that is the person who creates the trust. So the person who walks into the office and says, I want a trust, that's the grantor. Somebody sometimes called the creator, sometimes called the settler. The person who benefits from the trust is the beneficiary. The person in control is the trustee. That's the person who decides when the beneficiary will benefit. So, let's go back to the man who gifted his house to his son. He wanted to make sure his son got it. He didn't hear this presentation. Let's say you want to make sure your son, your child, your loved one gets something. He could have put that asset in a trust. He would have been the grantor. He could be the trustee in control, which meant that when his son died, he'd simply change who the beneficiary was and not be divested of his asset. So there are different types of trust. There are testamentary trust. Many people have this. It's a trust in your will. The will has to be probated first in order for the trust to be created. It is not a living trust. Then there are living trusts. Living trusts are trusts that are effective during your lifetime. So while people tell you that estate planning is just about thinking about your mortality, I'm here to offer to you that estate planning is one of the best ways to protect your assets for yourself as well as the generations to follow. It's not solely about thinking about your mortality. So there are two types of trust, living trusts. There's the revocable living trust and the irrevocable living trust. The revocable living trust is a trust that you can change in any way. You almost feel like you don't even own a trust. You can go to the bank, withdraw the money that's in the trust. You can take the bank account out of the trust. You can put more money in the trust. You can invest in a business in the trust. You can put a home in the trust. You do anything you want to do in the trust because it's revocable. You can change it in any way. Change the beneficiaries, change what's in the trust, change who the people are in control are. That's the revocable trust. So you're probably saying, so what's the purpose of this thing? I'll tell you what. The government created this trust just so we could avoid probate, just so we could avoid guardianship. Then there's the irrevocable trust. The irrevocable trust is a trust, a genre of trust that can protect your assets. If you owe assets that are less than $6.54 million, because that's the New York State estate tax threshold for 2023, then you can place your assets in the trust, decide who the beneficiary is, and control the assets. You do not have the flexibility you have in the revocable trust, but you're able to protect an asset. Let me give you an example. I want to put my homes in the trust because I always want to have that value. So I put my homes in the trust. I go in my car, I get in a terrible car accident. It's a 5-car pileup. People start suing me. You know which assets they're not getting? The assets in that irrevocable trust. I could change the beneficiaries. Let's say I name my son as beneficiary. He feels like, oh, she got an irrevocable trust. I can start acting any way I want with her now. I'll change you as the beneficiary. I'll change your percentage. You have quite a bit of flexibility, even though it's an irrevocable trust. You can keep income. Income could be a dividend. Income could be interest. Income could be rental income. All of these things can be kept in the irrevocable trust. I just want to quickly highlight to you the difference between a will and a trust. Wills, they do not speak until you pass away. So that means that you cannot protect any property to get to the next generation. You can't even protect it for yourself. That's why many people have trust, and when you sue them, there's certain assets you're not getting. So the will does not protect your assets. The will does not speak until you pass away. So it's whatever you have at the time of your death, with whatever judgments or claims against it. As I told you, wills can be a daunting process to probate. That probate process can be very daunting. But the great thing about a will is that you have complete control. The living trust. So many people come to me and say to me, well, I don't need a living trust because another thing that trusts do is they protect you from Medicaid reimbursement. So many people come to me and say, oh, I don't need a living trust to protect me from Medicaid reimbursement because I have great health insurance. I have some of the best health insurance, the Rolls Royce of health insurances. You know that Medicaid is the only true payer of long-term care. If you need assistance in your home with certain activities, or you needed to go to a nursing home, your health insurance does not pay for that. I want to debunk the myths and the misconceptions that you don't need to qualify for Medicaid and that you have too many assets to protect, and therefore you can't qualify. That is not true. See a good estate plan. Trust do not get probated. Have you ever heard of probating a trust? No. I'm not trying to tell you, though, that it can't be held into court, but they do not get probated. They are what is called self-administering. So after all the years or months that you take going through probate or administration in the New York State Court, that's where you start. After the probate process ends, that's where you start with the trust process administration. There's no, a client walked into my office the other day. I had created a trust for his grandmother about 2014, and she passed away. And he says to me, "What do I do?" I said, "Well, your grandmother put a property in this trust, so we're going to transfer the property to you now." He says, "And that's it?" I said, "And that's it." The real differences here between a trust and a will is you really can leave your instructions behind. I'm not speaking about controlling from the grave. I mean leaving your instructions. Let's say a married couple plan together, and they agree that when one of them dies, the other one would not change the beneficiaries once they get married or have a girlfriend. That's spousal planning. You can't do that in a will. You gave that to your spouse, it's theirs, they'll do whatever they want with it. Let's say you have a blended family. Two spouses get together and there's children from a prior relationship. We want to plan for that. You can do that in a trust. You cannot do that in a will. Or let's say you just want to keep your assets in your bloodline. You know, one of the worst things, I guess, for me, as the way I grew up, was for my family to give me something and it to end up in someone else's bloodline. In a trust, you can protect against that, not in a will. And then sometimes we have assets that we would not otherwise be able to acquire now in our lives, and we want to leave that behind. But we want the people that we leave it behind to understand this is to remain in the family. You can create a family trust to keep the property, to keep an heirloom. Okay, so very quickly, I'm going to go over the different options that I've gone over with you today. There's option number 1, where you do nothing. You defer to New York State's plan. You may end up with a guardianship. You may end up with an administration proceeding, and your assets may end up with New York State. Then there's option number 2, that you create a plan, but it does include New York State's plan. So what does that mean? You've created a will, and you've got to wait for the probate process to end. And maybe you have non-probate assets, and you don't know how those assets are going to pass to that person. And then there's option 3. You create your plan with your rules instead of New York State's rules. That's that healthcare proxy, the power of attorney, the living will, the will and the trust. So those are the options that I presented to you today. I'm going to stop because I know I've run out of time. Thank you so much.
Good evening, everyone. I am batting cleanup. I don't know how I'm going to follow these 2 presentations, but I'll do my best. If you've been with us from Sabbath School, this is where I started. I guess this is where I will end this evening. I learned a lot. Thank you. Thank you. I was taking notes, and there are things that I will revisit. Excuse me. And so I was asked today not to necessarily present, we've got in kind of what things we should do at end of life and things to do to protect our assets. But the title of the presentation this evening was Creating and Preserving Intergenerational Wealth. And to preserve something, you have to have it. And so while we are here, on this earth, while we are occupying and tallying, it is good that we position ourselves so that the Lord can bless us. Amen? Amen. If you had a choice, I choose to have resources versus not have resources. But you have to put yourself in a position to allow so. And so, most of what I'm saying perhaps may apply to those who are starting out in their careers in the 20s and 30s, perhaps even into the 40s. But if you're here and you're not in your 20s, 30s, or 40s, you can share that information with your children, with your grands. You can put this bug in their ear. Now, I just made a couple of I'm going to talk about a couple of topics which any one of them could be an hour presentation. And since we were supposed to keep 30 minutes for Q&A, that gives me about 10 minutes. I will go over. But if there's anything that you have questions on, please save it for the Q&A period. I will say I am not a financial advisor, so I don't have to offer a Safe Harbor Act, but let me offer one anyway. This is not financial advice. This is just information. One of the things I want to start with, and I've had this conversation several times with several people over the years, and I really do stand by this. We are stewards of God. Everything we own comes from God. And so if we are not being faithful to God, we are not positioning ourselves to be blessed. Susie Orman, Pete Ardrey, or Adani, Robert Kiyosaki, Warren Buffett, even Dave Ramsey's Christian, so he doesn't count. They all say the same thing. If you're not giving, you're not getting. They recognize that if you are not blessing others, you can't be blessed. And they're what we would call secular. So how much so that we have to recognize before we have any conversation about creating wealth and getting rich and getting that bag, that we acknowledge our role as stewards of God. That being said, I also want to make sure that we know, I want to put this in your mind. Literally, there's a mindset about money. And I say money's a tool. Do you know people who, they always just seem to have money? And they always got more than they need? And then there are others who have the same amount of resources, the same salary, but if you listen to them, they don't never seem to have no money, and they're always behind. Money is a mindset, and how we get it, keep it, and administer it is a skill set. And that can be learned. And the thing is, it's not necessary, it's certainly not taught in our schools. And depending on your bloodline or your parents' experience, you may not have been given direct lessons about that, or you might have picked up their bad habits, or even just not bad habits, but perhaps not optimal habits. So the way we think about money is a mindset, and it is, I want to say, it is a tool. And I always say, money solves money problems. It doesn't solve all the other problems. So thinking that you're going to win Mega Millions, and that's the end of that, and I won't have any more problems, that's the beginning of your problems. But let's talk about a couple things that we can do as we occupy that can build intergenerational wealth. They're all important, so I'm going to say, so there's no particular order. The first thing, and share this with young people, retirement savings, your personal retirement savings. There are a number of vehicles, but primarily your IRA. Those come in two varieties, Roth and just a plain IRA. You can contribute up to, for 2023, up to $6,500 a year of your own money into an IRA. You have the 401ks that are offered through your jobs. You can contribute up to $22,500. And if you're like in a public employee, 403B is a comparable plan. Now, here's the thing. Even the government has recognized that, depending on which side of the aisle you're on, Social Security may not be here for us. And if you're getting it now, great, but like me, who has a way to go, I'm a little concerned. So they want you to privately invest. Now, I think we should keep Social Security, but I think we should also privately invest. So now with the Secure 2.0 Act that was passed in December, a lot of things changed. So in the next coming years, I believe 2025, I stand to be corrected, when you join a company that offers 401ks, they will automatically enroll you. And they will automatically enroll you for a percentage of your salary, no less than 3%, no more than 10%. And it will also increase incrementally 1% every year until it maxes out at 10. Now, you can opt out of all of that. That's not a good idea. But they know that basically they're telling you you're on your own. It's you and God. So they want you to enroll. My personal experience, I remember straight out of college, I had no intention of staying at the job I was at. So I said, nah, I'm not going to do the 401k. I want all my money now. And the plan was 3 years and out. So maybe the third year, I ended up staying there 16 years. It was only in the third year that I said, yo, I'm not going anywhere. Let me get in on the 401k. I missed out on 3 years. And let me tell you, that might not sound like a lot, but those were boom years in the market. Don't feel sorry for me, but I'm okay. But look at that, 3 years. And why is 3 years important? Because we think about the savings. $6,500, how I'm gonna survive on $6,500, that's the max you can put into an IRA annually right now. That's 2 months rent and it's gone. No, that's $6,500, that continual investing and compounding, those little pennies, that 5 cent here and 10 cent here, that you don't miss, by the way, but when you stop and look back, oh my, where did all that money come from? But that's the point, that we want to continually invest in ourselves. One of the other things that I want to spend a little time on, I'm monitoring the time because I know there are going to be a lot of questions. For our children, one of the biggest expenses as parents in our child's lives is going to be some form of higher education. 529s were created to allow us to save in a tax-free way and tax-free appreciation for college. Now, the great thing is you go, well, and I hear it all, how I know my kid gonna go to college. Or that's not for us. Or you don't need to be successful, go to college to be successful. All true, but there's so much flexibility with a 529 now that there's absolutely no excuse. So what can you use? A 529 is an account that the earnings grow federally tax deferred and the qualified withdrawals are tax-free. So what are the qualified withdrawals? What can you use it for? In New York State, and there's a benefit. In New York State, there's $10,000 is deductible per couple. So you get a tax deduction for saving for your child's education. Now let me say, everything I say and anything that involves the state is complicated. So yes, there are going to be income limits and phase outs, but the fact of the matter is that this is a vehicle that we can start putting aside with, and I would dare say, the runaway cost of higher education. But what are the qualified withdrawals from a 529 plan? So we're talking about college, so tuition, fees, books, supplies, equipment, room and board while you're in campus. But wait, what about I want to send my kid to parochial school, private school? So now elementary and secondary education, those expenses, whether public, private, or religious, are now qualified expenses. But what about, well, listen, college ain't for everybody. My son is a wizard with his hands. What if he wants to go to trade school? Fees for apprenticeship programs and tools required for apprenticeship programs are now also qualified expenses. So with all of that, what excuse do we have? Now, there are a couple of things that go with it. Who can open a 529? Anyone can open a 529 for anyone. That means if you're a grandparent, you can open a 529 for your grandchildren. And you designate the beneficiaries. And what happens if your first grandchild wins a full scholarship? Oh, what am I going to do with all this money? You simply change the beneficiary to another grandchild. Or if you have 22 grandchildren and 8 grandchildren, you can pick any one of them that you want to change the beneficiary to. The favorite one. You can also, and there are even provisions for if, say, you've gone through all the grandchildren and there's still there's some amount of money there. There are provisions and there is a provision to take that money and roll it over into an IRA, a retirement account. And there are lots of rules, but the possibility remains. So this is a tool to help because college is scary, no matter how much you put away. One of my old bosses, we're good friends, we go out fishing once in a while, and he was saying, he has 3 kids. And he said, he said, and it's funny, it's all relative. He said, I have $200,000 for each of these kids, and I still don't know how I'm going to afford college. And I said, what? I said, if you're worried, I'm panicked. And again, college is expensive, and they're up and down the chain. So he's thinking, to be honest, Ivy, because he went to an Ivy, so that's the bill. State schools are a fabulous value, and then you have everything in between. So this is an opportunity as we go along. Now, when should you open a 529 for your child? When your child is born. It's the last thing you think about, but it should be done because think about it. You're saving, if God blesses you to put a $10,000 slug in there once a year, that's great. But God has certainly blessed you that you can put $25 a month, $35 a month, whatever it is, and allow it to grow. And it's invested. So it's similar to your 401k. It's invested, and you pick your profile if you're aggressive, conservative, age-based profiles. So there are lots of options. And the one thing, the last thing I would say with that, also as a community, you individually, but now you knowing, direct your gifts to the children. So instead of that fifth toy that will be played with for about 10 minutes and then goes in the corner, let me make a contribution. My little niece, who just turned 1, October passed, and I said, we went to the party and said, I forgot to give you a check. Forgot my checkbook. And my brother-in-law said, or my sister, they speak as one. They said, no, hold on, I'll send you a link. They sent me a link, a text, to her 529. You just push the button, how much you want to give, boom. So now when they go to college, you can say, I had a hand in that. You're welcome. I was part of me. What's one more toy? Really? We know the drill. The other thing, time is against us. One of the things I also wanted to say, in terms of generational wealth, insurance, it cannot be overstated. Now, this is not an insurance seminar. We've had those. There's term, there's whole life. I would encourage you to get educated on them. And I would also say there's no one size fits all, and you have to evaluate your own situation. Anyone who says, this is all it's bad, trust me, they got something to sell you. Or they just simply don't understand it. But just a couple of highlights about insurance that I want you to consider, because the purpose of insurance really is to provide, there's end of life, but during what we would consider the good years, our earning years, it's really to provide a replacement income should we meet our demise earlier than we planned. So think about it. I'm married, I'm the sole breadwinner. If I passed, what would my wife do? What would my kids do? What could I put in place for them? And so that's the point. But very important with that, 5 points. 5 points. Even stay-at-home spouses may need insurance as well. Just think about it. How do you replace that? I think I've seen articles where the value of stay-at-home moms is considering all spouses, forgive me, all of the duties that they undertake is worth about $140,000 a year between cook, chauffeur, cleaner, household manager, worth about $140,000 a year. So me going out, how would I replace that? Like, how long can I take off from work to take care of my kids and make arrangements? Single people need to be protected too. Now, if you're single and have, your assets consist of your futon and your secondhand car, you don't need $1 million, but you may need a burial policy. As much as we may not want to think about it, you may want to insure your children as well. And when I was reading this, I was like, that's kind of grim. But I could see myself, it said, how quickly could you go back to work? How quickly could you re-engage if something devastating happened? And I sat and I thought, I was like, my job gives me, 2 weeks grievance? And then you're back at work? So you might want to consider that. And this is very important. Too many people, especially women, are underinsured. And so you want to think about that. And then the most important thing, and I've seen it too many times, disability coverage may be more important than life insurance itself. I was really, in thinking about that, I was like, really? But a stroke, something catastrophic can happen at any time. One of my dear friends, we all know and love him. And I don't think it's not a secret, Elder Martin. We know he had a stroke. I was on the train with him when it was happening. And I remember we get off at Westbury, and there was something where I either had gotten a new car or something I wanted to show him. So he went into the restroom, I was waiting for him. It was taking too long, so I was like, well, I'll just show him another time. Because I know he said he didn't feel well. When I saw him on the train, he looked clammy, what have you. That was the last time he went to work. I was with him on his last Long Island Railroad ride. Now, he has things in place, God bless, his family's taken care of, but that was not the plan. I didn't know it was happening. He didn't know it was happening, despite it happening. And then the other thing, I'll end here because we're short on time. I can't understate, this is perhaps the most important point, and I want you to share this with your young people who are developing in their careers, who are coming up. The reality is, doing all of these things, making a budget, cutting out the extraneous, those are all perfectly good things to do. But cutting out Starbucks is not going to make you a millionaire. I know we only drink the chai latte from Starbucks, but not eating out is not going to put you in a Benz. The only way to create wealth is to increase your income, and that means increasing your value. That means educating yourself, and I'm not talking college, because college is not the only way to a successful life. Educating yourself, finding your passion and developing it, and then being courageous about going after and partnering with God. God has a plan for each and one of us, and it's to prosper us, but only when we provide the capacity for Him to bless. I'm going to stop. So that's the most important thing. We don't talk about that part. We can't save our way. Again, you can't save your way to a mansion. You have to increase your income, and that means adding value to yourself. Now, looking at the crowd, like me, I'm stuck with what I'm doing. I admit to that. But I look at my kids all the time, and I tell them, what do you want to do? You can do this, you can do this, you can do this, you can do this, you can do this. What are you passionate about? What do you think you want to do? And how do you get smart about that? Buy them books, make them read them, on a variety of topics, because they may not take it all, they may not understand it all, but those lessons stick with them. Time is against us. We're going to open the mics to Q&A for all three of us. And we're also taking questions on the internet, so however you're interfacing with us, I was told we'll have someone monitoring those platforms, whether it's YouTube, Facebook, to receive questions as well. So I'll turn the program back over to Sister Bennett.
Well, well, well. Could we just give all three a round of applause? Weren't they marvelous? Oh my goodness, I learned so. I just want to add something to what Elder Parkson said. I have two daughters, and I did not know about 529 when my first daughter was born. I think when she was 10, somebody told me about 529 account. I got on it right away. And I have to tell you, you can have them take it out of your account, start with $25, added 50. And because she was 10, there are different risk levels that you can take. I went to the highest risk. I'm saying she has another 15 years, right? You would be surprised how the interest compounds and how it adds up. And as and I said, I'm not calling him Elder Parker, as Mr. Parkinson Small said today, When you take that money out and you pay for books, there is no interest that is paid to the United States government. That is the most important. You don't pay any taxes on what you earn. When my second daughter was born, I did it right away. So the amount that compounded was astronomical. And start with $25. And I'm here to tell you, it was a big, big help. And the fact that you did not have to pay any interest on that amount is astronomical. So I implore all my young people who are here, who have kids, or if you're planning on having kids, I am not having any more, or I'd have to sue somebody.
Can I, Sister
Sure.
Betty, can I just share how passionate she is about this? She gave me the first $100 for Summer's 529. She just wrote a check and said, this is for Summer, put it in there.
And I tell my young people, I said, no, carry no toys when you have a party. Take it and give it money and put it on a 529 account. Because I don't give toys anymore to children. I might give you one. But after that, I am giving you money to put into your 529 account. I don't give toys. That's the parents. But I am here a testament to tell you that it works. So I'm imploring all my young people who are childbearing years, who have children, and especially also that 401k, when you start working, I told my daughter, you have no children, you have no husband, you have no life. Put the maximum you can in there now, because when you start having children, God help you. You will have to, so put the maximum. I said, put the maximum in there now, because you have a long life ahead of you. That's how I tell my children, all my nieces and nephews. But I'm going to.
And I have to share one thing that I forgot. Please forgive me. Why insurance is so important. Why insurance is so important in creating intergenerational wealth. Attorney Barrow gave us the statistics about the average wealth holding of white versus black and brown households. 122 versus 24? 188 versus 24. There are systematic, historical, legacy reasons. We know what they are. But there's one thing that in my studies, I've come to realize. The first shock of wealth for the average white household is an insurance policy. That's the first shock. Someone comes and gives you a check for $100,000. That begins the change in generational legacy. And let's be real, not 100,000, 500, a million, 10 million. That's the first shock of wealth for many white. And you're always wondering, how are they giving their kids $100,000 to buy their first house? I know what they do for a living. That's generational wealth. Insurance is very important.
And I'm going to turn over to, but I also want to point out, it is so important, the attorney that you use. And if you listen to Attorney Barrow, she says, be careful who you go to. Be careful who you go to. So she is here, a black woman, educated, and that's why I was so impressed with her, because I sat in with my friend as a witness and just watching her interact and how she interacted and what she asked, and I was overwhelmed. So be careful of the attorney. I'm going to turn it over to the mic, and I see Jeff at the mic, so I'm going to shut up and go ahead.
Good evening.
Miss, you want to say something?
Before we start, I was remiss in not introducing my next generation of funeral directors.
You're right.
My grandson, Michael Spivey, and my granddaughter, Tara Spivey Williams.
That's right.
Good evening. First, I want to also just applaud you three for coming. It's really, really knowledgeable with the things that you said this evening. My question when it comes to wills and trusts, in a household where husband and wife has, as you mentioned earlier, joint assets, there are assets that have beneficiaries attached to them, and then there's just outright separate assets. When it comes to wills and trusts, are those separate trusts together trust? Who should sit down in front of you to discuss the pros and cons, either will or trust? And then my second question is, those of us who have elderly parents, who has assets, who for all their lives never thought about having a will or trust, who just decided whatever I have go to my children. How do you now, or how can I now set up a trust for an elderly parent who just, in the mindset right now, their elderly is like, I don't, whatever happens, go to my last remaining son or whatever. Just what advice would you give on those two topics?
Whenever there is a husband and wife, I always, even though many spouses have separate assets, they usually also have joint assets. I ask them to come together. Unfortunately, it's usually the wife that's coming in without the husband because the husband doesn't want to sit down and discuss the assets and discuss planning. But I do try my best to get both spouses in together. It's best. So as I said today, before I made the presentation, that you were going to get this overview, I find that when I'm creating a plan for husband and wife, I try to create a plan that mimics their lifestyle. So if they want to. So what I mean by mimic their lifestyle, if you have separate assets, then you may need separate trust so that you can continue to conduct life the way you had been before planning. And then for the joint assets, we can put in a joint trust. But for the separate assets, I propose separate trusts. So maybe a husband and wife coming to me may get 2 separate revocable trusts for their bank accounts because you need access to your bank accounts and want to use them however you want during your lifetime. And then a joint trust, which may be irrevocable for the assets that you're trying to preserve to pass on. In terms of parents, or elderly parents, honestly, I always try to have the client that has mental capacity create their own plan. So while a person can create a trust plan for a parent, if the parent has mental capacity, I'm an advocate of them creating their own plan. Because if they have more than one child, if one child created the plan, that may not sit well with the other children. And honestly, I don't want to see my plan in a courthouse. I don't want to see my plan before a judge, so I tend to be, they say there's preventive medicine. I tend to practice preventative law, right? So I try my best to create the plan with the elderly parent. I'll hold their hands. I'll make them feel comfortable. And I will educate them about the different planning choices. I hope I answered your questions.
I just want to circle back on something that Parkinson said. When you go into the 401s and stuff on your job, if you and your spouse are making a certain amount of money, it's imperative that you just don't invest. It's imperative that one or both max out at $18,000. Because if you're able to live and set yourself up a certain way, that money's going to come back to you. Now, the 529, you get a tax credit of $10,000, but you can put a maximum away of $33,000 per child. Now, why is that important? When you come back to savings, we talked about good credit, good debt a couple of weeks ago. It's important to maintain your credit because if you put this money away in the 529, you got good credit. When your child calls you and says, well, I need money for college, you go to your credit card. And if you got good credit, you have a maximum number on your credit card. So you put that on your credit card, you call it 529, you get inside your account. Now, why would I do that? Because it's a strategy, as Parkinson was talking about, of handling money. You don't have to have a lot of money to have strategies. So if my daughter calls me and says she needs money for school, first of all, the 529, they're not that critical with you on the phone unless you tell them, I'm actually going to take this money out for a car or something else. They really don't care. I've been doing this for a while. However, no, but I'm not telling you I'm doing nothing dishonest. Everything comes through.
We are streaming.
Yeah, whatever. No, I'm just saying, because the other day I asked him about something that she called me about, and he was like, well, technically, I'm supposed to tell you this, but nobody really follows up. And I looked at the phone, like, okay, this is a recorded line. That's enough for the conversation. But we're talking about strategy. Let me just tell you about strategy. So it's important for us to keep our credit right and not destroy our credit, because that's how you get to maximize the amount of money in your credit card. So when your child calls you up and says they need money for college, you put that 15, 20, whatever it is on the card. You get the money directly from the account. You get $20,000 worth of points, and you pay right off. So now you walk away with almost 20,000 in points. Why are points important? Because we all go on trips. Why I got to buy tickets if I can use the points? So, and one more thing, the IRAs, right? The IRAs are $65,000 if you're under 50. If you're over 50, it's $7,500. And it's very important. It's very important that once you get most of your priorities out of the way, that you kind of set a goal to do it every single year, because as you get closer to the number, which is 59 and a half, when you're allowed to start getting deductions and things that nature back, that money's going to work. This money's going to work for you. And to be very honest with you, I'm always thinking about that, because nobody knows what happens around that time. So you kind of have to prepare. And in life insurance, I had a conversation with my youngest son, because my youngest son said, wait a minute, by the time I'm in college, what's going to happen then? And I was like, I put money away and I saved. However, I had three life insurance policies. One was term. One would already expired. So I had to get two others with my financial advisor to continue. Why? Because at the end of the day, nobody knows how long they're going to live. And you don't want to, my mindset is you don't want to overly leave an overabundance for your children, but you want them to say something good about you if you're gone.
Thank you, sir. Thank you, sir. Yes, I do appreciate the strategy, though. I do appreciate. I live on points. I live off of points. One thing we're going to go. We have another question at the mic. One thing two things about 529s, Justice By. Also, a qualified withdrawal, qualified use of 529 money. You can also now pay principal and interest on federally qualified education loans. So you can use you can use your 529 money if there's money left over to pay principal and interest on federally qualified education loans. Let me also share this, the most important thing. How do you open a 529? This is important because every state has one. It's important that you do New York State's, because that allows you to be eligible for the $10,000 per year per couple deduction. nysaves.org, O-R-G, nysaves.org. If you can open an Amazon Prime account, you can open a 529, just as easy. nysaves.org. Sister Brown.
Back to funeral arrangement. How would the bank know that I pass away and my daughter cannot get the money to take care of my funeral expense?
Say that, how does the bank know?
How will the bank know that I passed away?
Because when we file the death certificate, one of the questions that you have to give us is your social security number. And when we put your social security number in, it goes to Social Security. They confirm that it's the correct social security number for you, and there's a death list. that is created every day that goes out to the bank. And they go through this list and they freeze accounts immediately. So it's imperative that you talk to your funeral director to say, listen, I've got this bank account that I need to get money. I need this bank account to get the money to pay the bill. So the funeral home doesn't process the death certificate yet. They give you a work copy. You take the work copy and your contract for your funeral, and you go to the bank, and the bank draws a check to pay the funeral home, and they freeze the rest of the money until you get your certified certificate so that it can go to who deserves to get the money.
But my daughter is on the account, and okay, I'm an elderly person, and she been taking money from the account to take care of me.
Okay.
So wouldn't it be the same for her to take the money to take care of my funeral expense?
Yes, that account, both of your names are on that account. So the bank considers half of that money hers and half of that money yours. So if you pass away and she goes to the bank, say you have $10,000 in the account, and you pass away, they consider 5 hers and 5 yours. So she can only take 5 out, but you got a bill that's $10,000. She can't take the other 5 out until she gets all of the legal documents to do it.
Okay, thank you.
I guess everybody's clear on that. Go to the funeral home first. 2 questions I want to find, because it's coming up very often. So when somebody dies at home, exactly what should the family do? When they die at a funeral home, exactly who do they call first? How long can they keep the body at the funeral home?
Okay.
They're telling to take the body out. How long can the body stay at the nursing home before you...
It depends on, when the person dies in a nursing home, it depends on the nursing home if they have refrigeration. If they don't have refrigeration, then you have to get your loved one out of that nursing home as quickly as possible. Because what they use for refrigeration is a room that they put the air conditioner on. And they can't keep it forever. So when you have someone that's in a nursing home, it's imperative that you pick out a funeral home and know, so that when that nursing home calls, you're, number one, you're able to tell the nursing home, this is my funeral home. I'm using Greaves Hawkins Memorial Funeral Services. Sometimes they won't even call you. They'll call the funeral home first and say, Mr. Jones passed away. We haven't told the family yet, but we want you to know so you can come and get it. And then they call the family and notify the family that the person passed away.
When they die at home?
When you die at home, if you're under hospice care, you do not have to call the police. If your loved one is home and under hospice care, that means that the nurses come out to visit him, the doctors come out to visit them, their palliative care. You do not call the police. You call the visiting nurse service that you're working with. They will come out and declare the person is deceased, and we can go to the home and get them right away. If the person dies at home and they're not under doctor's care, you have to call the police, because the medical examiner gets involved, and the medical examiner, if the person has a doctor, will talk to the doctor to determine if the doctor can sign the certificate and you can go in, the funeral home can come and get that person. They have to release that person to the funeral home. If the medical examiner feels that there's something wrong with this death, they will take the body in. They'll tell you that they're going to do an autopsy. But if you do not want your loved one autopsy, you can decline. Tell them, I do not want you to autopsy my loved one. The only time the ME has a right to do an autopsy without your permission is an accident or homicide. But if your loved one died at home and they say, well, we have to take the body in to determine what they died from, You can say, well, I don't need an autopsy because they can examine the body, they can look at the pupils and all of that stuff and determine what you died from. They don't need an autopsy. And the same thing if your loved one dies in a hospital. The hospital is required by law to ask you to do an autopsy. They have to ask you that because hospitals have to do so many autopsies a year to remain accredited. They push this stuff on black people, and they want to always mutilate our loved ones for their experiment. They don't do that to white people. They do not do that to them. Trust me when I tell you. So if your loved one dies in the hospital and they ask you if you want an autopsy, we need an autopsy to determine what they died from. They've been in the hospital for 2 weeks. They know what they're treating them for. They know what they died from. They don't need that autopsy.
I just have a quick question. Can a living will and trust be registered with the court for safekeeping?
A living will is different from a testamentary will. So the living will, just to refresh your recollection, is one of the tools that I went over today that is used during your lifetime. The last will and testament can be submitted to the court for safekeeping. Trusts are generally not probated in a court. They're self-administering, and the average person that has a trust has it with them. It doesn't become a court tool and is not taken in by the court. So if you do have a last will and testament, you can offer it to the court in the county where you reside. The trust, on the other hand, is a private tool that is not offered to the court.
Thank you.
You're welcome.
Okay, we have a question from our online viewer. With regards to the MRD, I guess that's the minimum rule distribution, should one wait until 70 plus to begin taking money from one's 401k?
It all depends. A couple of updates. So the Secure 2.0 Act of December passed. That actually immediately increased the required minimum distribution age to 73, and it will continue increasing by 2020. By 2033, it should hit 75. But it really just it depends, and you have to consult your financial advisor. I will say though, with the minimums though, the Secure Act also reduced the penalties from a 50% penalty to a 10% penalty. It also introduced an opportunity for you to make a correction to that, and then the penalty is only like 10%. But it really just depends. It really just depends, as most financial questions do, on your personal situation.
Good evening, I have a question. If you file a power attorney with a lawyer, and if the person died, does the power attorney have no use no more? It's valid?
So the power of attorney is only effective during the lifetime of the principal. So that's the person who nominated the agent. It's only effective during their lifetime. So once the person who created the power of attorney transitions, that power of attorney is no longer effective.
Have any more questions? If anybody doesn't want to go to the mic, I'll be happy to pass this around because I know some folks don't want to get up. Anybody wants to ask the questions that's sitting? Going once? Vita, are you getting up to ask a question? Oh. Okay. Going once, going twice. And I just want to thank, I see some of my friends here. I didn't realize they were here. I sent it out, and we sent it out to other folks outside of our church. I see a friend here. Barry, that's my very good friend. I didn't realize he was here. I see June Allison Gray here, who also goes to another church. She's the one who introduced me. Do we have any more visitors that are not members of the Seventh-day Adventist Church or not members of this church? Just raise your hand. Oh, listen, I met this lovely young lady downstairs a couple weeks ago. Just stand up. Isn't she beautiful? I won't tell you how old she told me she was, but I'm amazed. She's 25. All right. Well, if there are no more questions, I really, oh, there's a question? Oh, I'm sorry. Oh, I have to bring, oh, only because I like you. Sorry.
I have a quick question. My mother resided in New York, but then moved to Florida. She made a will while she was in New York. Is it still valid now that she lives in Florida?
Her will, full faith, and credit. Yeah.
Yes, good evening, everyone. How long it takes to make a will? How long it takes to make a will?
At my firm, the will is usually created within a week. Trusts are different. It's a process. But the will is usually created within a week. So there's a point where you sit down and we design your will, and then we send the will to you so that you can read it in advance of signing it, and then you come in and execute the will. Trust, on the other hand, it takes maybe about from 4 to 5 consultations. So after you've engaged the firm, then we send you design considerations, things for you to think about in order to prepare to design your trust. And then we design the trust with you. Then we review the trust with you. And then you come in and execute the trust. And then after that, after the trust is executed, then you have a meeting to discuss funding your trust, because a trust is not effective if it is unfunded. And that's something very important in our firm. So we have a meeting just to discuss the funding of the trust. So that's why it usually takes about 4 meetings with trust planning.
Another question, what's more important between the trust and the will? And should you have both at the same time?
So you can have a will without a trust, but you cannot have a trust without a will. And the reason why you don't have, estate planners don't create trusts without wills is because, as I said earlier, trusts must be funded. So sometimes people come into my office and they just want the irrevocable trust. And if they just want the irrevocable trust, normally there are assets that are left outside of that trust. So then the will acts as the safety net to capture the assets that may not have been funded into the trust. If the person hires the firm to get both a irrevocable trust and a revocable trust, then there's generally no assets left outside of the trust. But as an estate planner, I can't make that assumption, so I'm still going to create a will for you. In terms of which one is, did you say better? Mm-hmm. I think that's subjective. It is based on what your goals are. So are your goals to avoid probate? Are your goals to protect assets? So it depends on what your goals are. Once we ascertain what your goals are, then we can make recommendations as to whether you are trending towards will planning or towards trust planning. So in the initial consultation, that's what we discuss. What type of planning you really are desirous of having, and we flesh that out during the first consultation. In order to do that, however, we give you this personal information form that is extremely intrusive, and that has to be completed so that your initial meeting is tailored to you, and we can show you what the different plans are and what the different outcomes would be based on your personal information.
Thank you.
You're welcome.
Here. Please explain funding the trust. Is it a one-time thing or continuous?
Funding a trust means that you have placed the assets into a trust. And I'm really glad you asked that question because I didn't really get an opportunity to cover it during the presentation. Many people have trusts that have nothing in it. So in order to fund a trust, you have to change the title of the assets you have from your individual name into the trust name. So for instance, if you wanted your bank account to be in the trust and it is currently in your name and your name is Jane Doe, and you created the JD Trust, the bank account is going to be, you're going to create a new bank account in the name of the JD Trust, with Jane Doe being the trustee. If your asset is not labeled that way in the name of the trust, so it's not titled that way, then your trust is not funded with that asset. So a great example is, if you look at a will may say, I give all of the things that I own, no matter where they're situated, to my son. And so when you die, everything that is in your name goes to your son. The trust may say, I give everything I own, no matter where it's situated, to my son. But if the trust doesn't hold any asset, then nothing goes to your son. It is an ineffective plan. So if you have a home, you have to change it into the name of the trust if you want it to be a trust asset. If you want to create a bank account for the trust, you have to create a bank account in the trust name. If you have a stock portfolio, you have to change the title of the stock portfolio into the trust name in order for it to become a trust asset and be funded into the trust.
The five factors that you gave us, is it important that we carry out all five?
You mean the 5 tools, the
Yes.
healthcare proxy, power of attorney?
Yes. Is it important that we carry out all 5?
Again, that is based on your specific vision for your planning. So it's important that that be ascertained at some point early in the process. A person can come to me and not want to do trust planning, therefore they don't need a trust. They would only have the will. I think the healthcare proxy is extremely important, and the power of attorney definitely is important. So you can have a will, a healthcare proxy, a power of attorney. You can choose whether or not you want to have a living will, which addresses what happens to you if you're ever deemed terminally ill or permanently unconscious. But that's up to you. It can be sufficiently addressed in the healthcare proxy as far as I'm concerned, but you do not have to have all 5 tools. You might have a will, a healthcare proxy, and a power of attorney, or you might have a will and a trust, healthcare proxy, and power of attorney. It's really up to what your vision is for your planning.
Barbara, can you give me 1 second? Let me just
Just a quick question. When you create a trust, I believe, and you can correct me if I'm wrong, you also have to have a tax ID number associated with that trust. Is that correct?
It depends.
On what?
It depends on your assets and what type of trust you're creating. If you're creating a revocable trust is considered a grantor's trust and doesn't require a tax ID number. The entity can be disregarded, the trust can be disregarded, and you can be taxed directly as an individual. If you create an irrevocable trust, and your assets are sufficiently less than New York State's estate tax threshold amount, which is that 6.54 million, then you can create an irrevocable trust that is also a grantor's trust and does not need a separate tax ID number and is also not taxed at a trust tax rate. Not all attorneys create that genre of trust. If your assets are close to or above the New York estate tax threshold and you want an irrevocable trust, then you will create an irrevocable trust that will require a separate tax ID number, and you will not be able to be the trustee.
A quick question. If you set up a trust and then you die and the people who you have left the trust to, they also passed on, what happens to the trust?
In planning, especially when you're creating a trust plan, you're going to have a scheme of ways for your assets to be transferred to successor beneficiaries. When I create a trust, I even create a section that is called the ultimate beneficiary. So if who you stated initially passed away and the successor beneficiary passed away, then finally your ultimate beneficiary, your beneficiary of last resort, who would that be? So sometimes, as an estate planner, we realize that generations are lost at one time in one occurrence. And because of that, it's very important that there be an ultimate beneficiary, so that is thought of. So a well-drafted trust is going to take into consideration generations lost at one time.
Online. Thank you, Elder Parkinson. Thank you, Carol. Another question. What is the average fee to create a trust? And also, can't your retirement go into a trust? Retirement income.
Okay. So the average fee to create a trust depends on the type of trust. The revocable trust, the base trust at our firm starts at $3,500, the base revocable trust. The base irrevocable trust for an individual starts at $5,500. So the revocable trust goes as high as $4,500 for an individual, and the irrevocable trust goes as high as $6,500, but it starts at $55,000. So the retirement income, as you beginning to earn it. So in New York State, your retirement income that's set aside in a retirement product is a protected asset. However, as you begin to draw down on it, it then becomes unprotected. So if you're at a point of having to take required minimum distribution, and at that age is at 73, then you would be receiving that income, and that income that you're receiving is then unprotected and can be placed into a trust. So when I meet with a client, the reason why I always ask them to fill out the personal information form is because we discuss things like that. Ways of taking out your retirement income without being penalized and protecting it depending on whether or not you need it. So if you don't need the retirement income and you're not using the retirement income, we can discuss whether or not it's wise for you to withdraw from that retirement income on an annual basis, placing it into a different type of product in the trust and therefore protecting it. So if I'm sitting with a client that income is sufficient for their lifestyle and they have this wealth of money sitting in their retirement, in a retirement product, I might suggest to them to consider moving it over into the trust into another product. Also looking at their tax bracket and so forth. So that's something they'll have to discuss with their financial advisor. But If you're over 59 and a half, you can withdraw from your retirement income without penalty, just being taxed. But you're not required to withdraw from it until you're 73. So those are considerations that are discussed. That's why I say that each client that sits with me, I discuss their situation by situation. In other words, client by client. It's not a cookie cutter type of consultation, the initial consultation. It's a consultation that is tailored to the person.
Yeah, quick question on insurance. If you don't have any children and you're covered with insurance from your company, do you still need to purchase additional insurance? Whoever covers insurance, life insurance.
Okay, if it's in relative to the funeral home and you have job insurance, if that job will accept an assignment, which is telling them to pay the funeral home whatever the funeral bill is, then you can use that insurance. But if you work for the city of New York and you have job insurance with the city of New York, they do not deal with funeral homes. So that insurance is no good to help you pay for your funeral bill.
In general, there's a big argument because people would say, okay, you don't have beneficiaries. Depending on your lifestyle and your income, you might want to bless someone. You take out a policy on yourself and then upon your demise, okay, Linda's school gets a brand new building. That may be something you want to do, but generally, you're not providing for the support of any other, and so the argument would be made, it's an unnecessary expense.
The other thing with job insurance is when you're employed, the job insurance meets your yearly income. Once you retire, that job insurance decreases. So that might be the time. So when you see that, then you might need to consider getting additional insurance to cover that loss.
So it may decrease to a nominal amount, like maybe $2,500, $5,000, which would not cover the costs of funeral arrangements and can't really provide for anyone. So I find that most insurances offered by employers are beneficial if you pass away while employed, right? But if you wait, then the other thing is if you wait then to be insured, although you may be able to get insurance, I don't know how much insurance you'll be able to get, right? So it's beneficial to get insurance while you're younger and healthy, right? Premium is less and so forth.
Oh, I have one last question. I think one of the main reasons why even the poorer, then, bad term, but the poorer people might, be hesitant to, go for these services is because they can't afford to. They can't afford the fees to do it. Is there like a payment plan, in place that they could use to help them to make this decision? Because I see that it's a very important decision to make.
Who is this question for?
Miss Barrow, sorry. Miss Barrow, the question is for you.
Yes, ma'am. There is a payment plan. Yes, absolutely. And there's so much of a payment plan, we even accept credit cards. There's definitely a payment plan. I recognize my community, and I think it's so extremely important that we plan, that I do my best to work with the community. And I can honestly tell you, I haven't raised my fees in maybe 10 years. I just don't do it. You're welcome. Yes, ma'am. So I didn't speak about Medicaid because of the time constraints. Usually I give more hypotheticals or stories about Medicaid, but it's very important to realize that in trust planning, especially that irrevocable trust planning, sometimes some attorneys even call it Medicaid planning. That it is that trust that protects our assets for us during our lifetime so that we can get care. So right now, there is something called community Medicaid, where we can get someone to come into the home if we otherwise qualify for Medicaid. And trust planning is one of the best ways to protect your assets so that you can qualify for Medicaid and not be subject to Medicaid recovery. So you can have assets in millions of dollars and still protect them and qualify for Medicaid.
Absolutely. Absolutely.
Sorry, I was just asked, is that subject to a 5-year look back by Elder Small? So I want to say that if you're looking to get, to qualify for Medicaid in a long-term care facility, then the assets must be in the trust for 5 years to be 100% protected. An elder law attorney is going to still come up with a workaround, at least if your assets have been in the trust for about 3 years. But if you're looking for community Medicaid, right now, you can be eligible for community Medicaid after placing your assets in the trust for 30 days. However, in 2024, there will be a 2.5-year look back implemented by the federal government. So it behooves you to plan as early as possible.
Could we just give them a round of applause? Before I conclude, has everybody signed this list? Okay. I want to thank each and every one of you, Attorney Barrow, Parkinson Small from and Parkinson Greaves Funeral Home. Thank you very much from the bottom of our hearts for providing such interesting information and timely information. As Parkinson said, God works in a mysterious way, because when we planned this program, we had no idea that this week's lesson was talking about how God wants us to do estate planning. So it was just God works. It was not us that planned this program today. It was His intervention that caused the Sabbath school lesson this week to coincide with this program. So I just want to give Him all the praise, all the honor, and all the glory.
Of course.
And I just want to thank each and every one of you for the profound information that you each have provided. You are always here providing quality services for families when their loved ones pass on. So I want to thank you. Elder Parks is here not only as an elder, but he's also a brilliant mind. Tap into him. He has the expertise. He has the information. He's here. Attorney Barra has given you her pamphlet. Look into it. Call her. And as Lorna asked the most important question, and that's a real question, she will work with you. If you don't have it, no, and a payment plan. And if you can pay $10 today, she does $10 worth of work. And then when you bring it up, she'll do $20 worth of work. So when you give her, she will ramp it up depending on what you give her. But it's really, really important, especially for our community. For our community who do not take this. Let me just tell you, and it's my story, my family story. Our cousin, don't know if you know, Beverly Bailey is my cousin. We have a cousin, his funeral is tomorrow. He just turned 60. His desire was to retire. That's all he talked about. And he wanted to live in South Africa. He went to South Africa in November. And he came back. He didn't go to work for a week and a half, and they're wondering what happened to him. When they went to his apartment, they found him dead on the floor. He just learned he had diabetes. He died of a diabetic heart attack. Let me tell you, he had no will. No will. He has an apartment in the Bronx. He has accounts. Right? My cousins, who are his brothers, they all live in Jamaica. The only family he has here are us. People have been going to the funeral, because he died at home, they had to do an autopsy. Folks have been going to the medical examiner's office claiming there is his body, this is his family, this is his partner, this is his this is his that, because they see money. It is a mess because he had nothing put on paper. He has money in the bank account, he has an apartment, and we are seeing it happening to us because he did not think that he's a picture of health. So I am telling you from my perspective, and my 3 cousins who live in Jamaica, luckily one is an American citizen, so he can be the administrator. If he was not, then the court would have to provide an administrator. People have been trying to get his account because they think he had no family, but they're all in Jamaica. So I'm telling you the importance of putting this in place because nobody thought, we were just together in Jamaica in November. Nobody thought he was going to die. Picture of health. So so I can tell you my story, and his funeral is tomorrow. So it is extremely, extremely important to take this information seriously. So I just want to thank each and every one of you. I'm going to ask our first elder if he could just close us out with the closing prayer.
This is all stand, please. Before I pray, I just want to say to the panelists, Mrs. Barrows, the park is small and Mr. Grieve, very, very informative program. Thank you very much. Let us pray. Father God, we thank you for the information shared today. Help us, oh God, to implement it where it is necessary for those of us who have concern in any of the areas we just talked about. Bless our families. Thank you for those who came by. And Lord, take us home safely. Help us to have a productive and a blessed week. We pray in Jesus' name. Amen.
For those of you who did not get a package, please fill out the attendance sheet, and I will send you the package. Okay? And for anyone who wants the personal information form,